Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that's pretty shocking. Now, this is a case from 2021, but it was just recently mentioned in the Canadian Parliament, and that was in the context of Paul Bernardo's transfer to a medium security prison. If you don't know who Paul Bernardo is, he's one of Canada's most notorious murderers. His crimes are horrifying to a degree that I can't really go into detail about them on YouTube or I'll get removed. But what happened in this case is that the families of the victims of some of the most horrifying murders to have taken place in Canada were forced to pay the government. Let's have a look at this case. As I mentioned, it's one that I think the public would be pretty horrified by. All right, so you can see there's a whole lot of people suing here. Here we have Fraser, Karen Fraser, Jennifer Sweet, Nicole Sweet. This is the families of Constable Sweet. We'll talk about that in a moment, as well as the Toronto Police Association. So that's one group of people who brought this case. And that's against the Minister of Public Safety and Emergency Preparedness, the Attorney General of Canada, Correctional Service of Canada, Parole Board of Canada, and Craig Munro. He is a notorious murderer. We'll talk a little bit about what he did. There's also Doug French, Donna French, and Deborah Mahaffey. These are the families of the victims of Paul Bernardo and Carla Homolka, against the same people as well as Paul Bernardo. The CBC also gets involved. They have a somewhat tangential role here. All right, so let's sort of look at what happens here. This is regarding judicial review applications of 6 decisions, 4 by the Parole Board of Canada, Parole Board, and 2 by the Correctional Service of Canada, denying requests for the further disclosure of personal information about 2 incarcerated individuals, Craig Munro and Paul Bernardo, together the inmates. Of these requests, 5 were made pursuant to the Access to Information Act, and 1 by way of letter requesting disclosure based on the open court principle. I will dismiss these applications for the reasons that follow. So essentially what happens is that the families of the victims of these murders they asked for more information because these individuals were up for parole and they wanted to oppose that. They said, hey, these are people who should never get out of custody. We're opposed to that. We need information so that we can prepare for these hearings because we want to make our voices known as victims. So, they were asking for a bunch of information, including admission and discharge records, case management reports, discipline and disassociation reports, education and training, healthcare, preventative security, psychology, sentence admin, visits and correspondence, a whole bunch of information. So the court is going to describe them a bit in terms of who they are. So the first group that we mentioned, the sort of Sweets group. So these applications are for the judicial review of the Parole Board and CSC decisions denying the disclosure, either in whole or in part, of the personal CSC, Correctional Service of Canada, and Parole Board files on Mr. Munro, and the disclosure of recordings of Mr. Munro's parole hearings. Mr. Munro was convicted of the brutal murder of Toronto Police Constable Michael Sweet in 1980 in a case that garnered considerable public and media attention due to Mr. Munro's cruel and repugnant conduct. The 1358 applications are made by relatives of the deceased Constable Sweet, i.e. the Fraser and Sweet families, and by the Toronto Police Association. Now, if you're not familiar with this case, it's from the 1980s, but this is a really horrible case. Basically, a bar was being robbed, and somebody went and flagged down a police officer, Constable Michael Sweet, and he went and said, I will respond to this. I'm gonna go be a hero. And he did his best, and he is a hero. So he went and charged into this bar to try to stop the robbery. Unfortunately for him, the Munros were there, and they got the drop on him. And they were armed with a handgun and a sawed-off shotgun. They shot him, and he was mortally wounded, but he wasn't dead at this point. So because he's there lying there bleeding, Mr. Munro realizes that he's in a lot of trouble. And so now he's using Constable Sweet as a hostage. And so this whole hostage situation unfolds where they're saying, hey, we'll kill him, or, and they're making all sorts of demands. Now, the police force as a as a force, decided to pull a Uvalde, and they were ordering their officers not to go in. So they said, "Don't go in. We're going to solve this." Meanwhile, Constable Sweet is begging for his life. He is telling these guys that, I've got a family. And there's another officer outside who's sort of manning the door. And he's listening to all this. That was an Officer Anderson. And eventually he just can't take it. He says, "No, screw their orders." And so this guy is also a tremendous hero. He goes in, and several other officers go in with him, and they manage to overcome Mr. Monroe. And they would have rescued Mr. Sweet, except that by this point, blood loss was too much, and Mr. Sweet died. The entire time that he was in there, Mr. Monroe could be heard taunting him. And apparently Mr. Monroe took the opportunity to use drugs while this was going on. So this was something that really horrified the public. It was absolutely tragic. And in a further tragic situation, the Mr. Anderson that I mentioned, he had serious PTSD as a result of it and didn't survive all that long. I'll let you fill in the blanks on that one. YouTube doesn't like certain topics. But yeah, it was a truly tragic set of circumstances, and one that quite properly horrified Canadians. So that's who we're talking about here. That's Mr. Monroe. The next group here, and I'm not going to elaborate on this one because the crimes are sexual violence as well as homicide, and so YouTube gets very touchy about that. For their advertisers don't like it. So Mr. Bernardo was convicted of a series of offenses, most notably the horrific first-degree murders of Ms. Leslie Mahaffey and Ms. Kristen French in the early 1990s. This case garnered considerable public and media attention due to Mr. Bernardo's cruel and abhorrent conduct. The applicants seek the release of all materials and information that were before and/or available to the parole board, as well as complete copies of the audio-video recordings and the transcript of the parole hearing held on October 17th, 2018. So basically, they also want information to say, hey, we're opposed to his release. We want to keep him in custody. So the records the family seek, in their own words, are their entire Correctional Service of Canada files, commencing from the first day they entered the Canada Correctional System regarding any offense, including trial and sentencing transcripts. Their entire PBC files, commencing from the first time that they came under its jurisdiction, regarding any offense, including trial and sentencing transcripts. That's the Parole Board of Canada. In the case of Craig Monroe, details of his 1979 mandatory supervision release and the conditions he was on at the time he murdered Police Constable Michael Sweet. He was on parole. More specifically, after Monroe's first ATIP request, all ATIP requests included the disclosure of the entire CSC and PBC files that were directly or indirectly before the PBC for each hearing, or which they had access to, as well as the materials that were before and/or used by the CSE and the case management team for the purpose of presenting their position at each parole hearing. In the case of Craig Monroe, documentation regarding his institutional offenses, so offenses he committed while in custody, which resulted in his January 2016 transfer from the minimum security, I'm not going to be able to pronounce that, I'm afraid. I don't know the pronunciation, and I'm just going to get it wrong, institution to the medium security Matsqui institution. In the case of Craig Monroe, documents explaining the breaches and offenses leading to the cancellation of his UTAs, unescorted temporary absence, in 2012, and consequently the cancellation of his 2012 parole hearing, including full details of his positive cocaine tests, his involvement with the sex trade workers, and how he went about to hide this activity from his CMT, contrary to the conditions of his UTAs. So he was not behaving well while he was on an unescorted temporary absence, is what that's telling us. In the case of Craig Monroe, the circumstances and facts leading to his February 2016 withdrawal of his application for unescorted temporary absences, production of the audio recording and transcript, if they exist, of all of Monroe, Bernardo, and Gale's parole hearings, In the case of Paul Bernardo, the ATIP request included all documents relating to his application to be relieved from the full consequences of his dangerous offender designation. Dangerous offender designation in Canada means that you've been flagged as a particular risk. And what that means is that you can be held in custody past the expiry of your sentence until they determine that you are not a danger anymore. So a dangerous offender designation basically puts you on an indefinite sentence until and unless you're sort of cleared to be back in the public. Including all medical records and reports addressing findings supporting the dangerous offender designation and all evidence tendered at his dangerous offender hearing, i.e. victim impact statements of the Scarborough rape victims, transcript of the hearing, and reports filed. So they wanted all of this stuff, right? And when you think about it, it doesn't seem like an unreasonable ask. They're basically saying we are the families of the victims. We're sort of second order victims, if that makes sense. And we want this information in order to be prepared when we come in. They're invited to make submissions as to why these people shouldn't be released. And so they're saying we want to actually have the information to make those submissions. Now, this is a long case, and I don't want to go through all 108 pages of it. So I'm just going to sum this up by saying that ultimately the court determines that they dismiss the applications. They determine that the privacy interests of the offenders outweigh their interests as, people who want to find this out. So, and in part, they say that that's because the media has been able to attend the parole hearings. So there's been some information available, to the public, but the private information should not be released. So the families lose. And I mean, this is the thing. This is not the part that is most outrageous. People lose in court all the time for a variety of reasons. But the thing that will really horrify the public, keep in mind, these are the relatives, the direct relatives of the victims of, as mentioned, some of the most horrific murders to have happened in Canada. The little bit of description you got there hopefully has got you convinced that these were horrible crimes. Now, in Canada, after a court battle, the winner usually gets what are called costs, which is money. Now, that doesn't apply in criminal cases, or at least doesn't usually happen in criminal cases. But in civil cases, it's quite common that they'll get costs. And costs reflect usually a portion of what you've spent, not full recovery, but it defrays the cost of bringing the litigation for the winner. Now, there are exceptions to that. There's circumstances where you might not get costs, and there's circumstances where if you're the government, you might think that it might be best not to seek costs, because the government isn't like an ordinary litigant. The government isn't like somebody who's suing their neighbor over a fence or something like that. The government has higher responsibilities towards justice and fairness and all of these sorts of high principles, which don't really come up in a dispute between neighbors or business partners. And so that should really temper what they seek. But we're going to see something else. So let's have a look. Costs. Both the families and Canada provided post-hearing submissions. So after it's been decided, they already know that the government has won on this one. On costs and bills of costs for the 5 applications they brought. The parties were unable to agree to an amount, which isn't surprising when you see what their respective positions are. So the family's bill of costs, dated March 11, 2021, was $33,195.01. So that's what the families are asking for at the end of it. Now, normally the losing party doesn't get costs, but there are some exceptions, and they're asking for it. Canada's was $19,142.27. The families submit that they are entitled to their costs whether they win or lose. In the alternative, so if they don't get their costs, they say no cost should be awarded against the applicants. And the reason why they make these submissions is they say the families assert that this was a test case and public interest litigation, and so should be treated differently. Okay, that's debatable, right? As to whether it's public interest or whether it's their private interest, right? That's a debatable point. But I think the next point is really hard to refute. They say, as well, the families have suffered enough, and the Canadian public would be shocked if costs were awarded against them. I think that one, it's hard to argue with, right? The submissions go on to ask that even if they are not successful, that they should be entitled to costs because the clear message from Parliament is that the public benefits from these types of legal proceedings, and they should be encouraged. There should be no sword of Damocles hanging over the heads of Canadians who bring forward responsible and bona fide public interest cases. I think that this is a reasonable proposition, right? Especially when we're talking about people challenging the government. So they then bring a number of reasons why they should be awarded costs, including they mention some cases. Canada, so this is the government on behalf of the public, right? That's me, that's you, assuming you're a Canadian viewer. This is them acting supposedly in our interest, right? Their submissions are that as members of the public, that costs should follow the event, and that they should be awarded an inclusive lump sum of $19,142.27. So they are going to the victims of these offenses, like the families of the murder victims, and saying, we want $19,000 because you brought litigation against us that was ultimately unsuccessful. This amount calculated on the basis of column 3 of the tariff schedule. So there's a schedule that basically provides for default amounts. So Canada argues that the families have not provided a valid argument to have me exercise my discretion otherwise, given that they do not meet the factors to be considered a public interest litigant. So this is just, there's a test for that, and they say they don't meet the test. And the part of the reason why is they say that this application is not public interest litigation and is in fact an inherently personal interest, as is their personal motivation is to use the information sought to make statements to the parole board. Sure, but I kind of feel like the public might have an interest in having the victims make submissions, right? So that is that's an issue there. All right, so the court makes a ruling here. They say, though I agree with Canada that this is not a public interest matter or a test case, I do have discretion after considering all of the factors listed in Section 400 of the Federal Court Rules. The families have suffered enough. So the judge here is not giving them the full $19,000 that they asked for. What I heard in the lengthy application is that the families really are seeking legislative change that is accomplished politically. However, an application for judicial review is not the vehicle to achieve what they seek. I considered the submissions regarding the family's particular financial situations and will award costs to Canada as the successful party in the lump sum amount, including of taxes and disbursements, of $4,000. The inmates, that would be Mr. Monroe and Mr. Bernardo, did not participate, so will not receive costs. That's a good thing, right? I think the public would be even more horrified if the murderers had been paid money out of this. Nor will costs be awarded against the intervener CBC. So at the end of the day, the ruling includes that they have to pay forthwith the amount of $4,000. And that includes all fees, taxes, disbursements. So that's all in. They have to pay $4,000. Now, I don't know about you, but as a member of the public, that is supposed to be, we're supposedly the ones that I guess are being kind of represented here in a way. I don't know that I feel super thrilled about these families being hit up for $4,000. Quite frankly, if I was the government on that one, maybe they've got good reasons to fight the case, right? That's a separate issue in and of itself. But at the end of the day, This was not the time to say, hey, we need costs. This was the time to say, you know what? We're good. Like, the public interest is not served by seeking money from these victims. Again, these were crimes that horrified people. They weren't sort of run-of-the-mill murders. They were really, really horrific crimes. And our government said, we want you to pay up. Yeah. So this one was recently mentioned, as I said, in Parliament. This was brought up to say, hey, why did this happen? And the government, of course, doesn't have a good answer for this. I don't think that there is a good answer that can be arrived. Quite frankly, the thing that the government might want to consider doing, now that this has been brought up in Parliament, is saying, maybe we'll give them the money back. It's just a thought. The families of the murder victims, do you think maybe you want to give them that money back? Think about it, Mr. Trudeau. It's $4,000. I mean, in the space of the Canadian budget, this is pocket change. But it's an insult. It's an insult to anybody with compassion for these families. So think about it. Maybe pay them back. It's only the right thing to do. All right. Well, thank you guys for watching. I hope you found this to be, horrifying. I was going to say interesting and educational, but educational maybe, but I mean, this is tragic. But if you want to see more content like this, please hit the like button, share this with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, the CCFR, CAIM, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babe and Luxor. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.